Welcome to the Kids Caught in the Middle video series. Today's episode is about Chapter 10, Adoptions. My name is Liisa Speaker, and I wrote the book Kids Caught in the Middle, How Families Are Harmed When Judges Don't Follow the Law. Now, I could have written an entire book on adoption law, and you know what? I still might do that one day. There's so much to cover, we're barely going to scratch the surface today. But I wanted to talk about 5 different types of adoptions. But I also wanted to point out that there are only 3 types of adoptions covered in the book. So you're going to get some bonus material today, albeit briefly, but just to give you an idea of different types of adoptions that are available out there for your clients and for the parents who maybe are looking to find an adoption plan. One type of an adoption is called a direct placement adoption. And what usually happens in that case is that an unmarried mother decides that she does not want to raise a child that she had with maybe a one-night stand or a short-term boyfriend. And because they're not married, she can make an adoption plan. And what happens is after she gives birth to the child usually goes home with the prospective adoptive family directly from the hospital. So that child only knows the one family, the family who is intending to adopt the child. But she still needs to seek termination of the father's parental rights before the child can be adopted. So there's a lot of steps involved at this point in the case. So a lot of putative fathers are more than happy to release their parental rights so that the child can be adopted. But when the putative father comes in and requests custody, that's when the real work begins, because the judge has to go through a whole series of findings before his rights can be terminated. The first thing she or he, the judge, has to decide is whether the putative father provided substantial and regular support to the child during the pregnancy or in the 90 days before the adoption hearing was noticed. And if he didn't do that, if he did not provide substantial and regular support, then she has to ask whether he's willing and fit to be a parent and whether it's in the best interest of the child for him to have custody. Now, going back for a second, if he did provide substantial regular support, then the adoption cannot be finalized under this section of the adoption code. So one of the key things is that in a direct placement adoption case that we're talking about, which is under section 39 of the adoption code, there is no DNA testing. So if the man comes in and says, I want custody, but only if I'm the father, that does not matter under the adoption code. He cannot get DNA testing under the adoption code. That is something that should not be allowed by the judge. Another type of adoption occurs when the parents' rights have already been terminated because they were part of a child welfare case for abuse and neglect. And sometimes the child is fortunate enough to have a family that wants to adopt him or her, and other times the child might even have more than one family. There might be a foster family who the child's been living with, but there might also be relatives who want to have that child in their home. And so both families have to request to adopt, and the Michigan Children's Institute, MCI, is the one that gets to decide who to grant consent to adopt and who to deny consent to adopt. And if whoever it is, the foster parents or the relatives, have been denied consent to adopt, they can then go to the circuit court and complain about the MCI's decision. And by doing that, they have to meet a very, very high burden. I think it's one of the hardest burdens to meet under Michigan law. They have to show that MCI's decision to deny consent was arbitrary and capricious by clear and convincing evidence. Now, there's a bunch of procedural quirks with these cases that are known as Section 45 cases, and so you need to be really familiar with the statutes and case law and how these cases work, because the timing and other issues are pretty tricky and really don't favor the person or family who's been denied consent to adopt. A step-parent adoption is a third type of adoption, and it's also under the adoption code. Now, what often happens is that the parents are no longer together, and let's just use the mother as an example. She remarries, and her husband is maybe the only parent that child is known as a father. And so she wants her husband to adopt her child. But before she can do that, she needs to terminate the parental rights of her ex-husband or whoever the father is. But she can only do that, or who the parent is who's seeking to do the adoption, can only do that if that parent has been not supporting the child substantially for at least 2 years and also hasn't been communicating with the child for at least 2 years. So if you're a parent and your ex gets remarried, you need to stay involved with that child's life, both in contact with the child and also by supporting the child if you want to avoid a step-parent adoption down the road. Now, there's some tricky legal things with step-parent adoptions. The statute is a little weirdly written. There's been lots of litigation over the language of the statute, and it's been amended at least once, and it's probably going to be changed again because of all the problems the wording has created. So just be very wary when you step into a step-parent adoption case that there are some quirks that you should be wary of. Now for the bonus material. We have two more types of adoptions. One is an adoption by a guardian. We mentioned it in Chapter 9, guardianships, when we did the video before. You can go watch that. But a guardian can seek to adopt a child, but first has to terminate parental rights. And there's some special rules that apply to a guardianship adoption. And the last type of adoption is under the Safe Delivery of Newborns law. Now, this law comes into effect basically when a distressed mother who's in a crisis pregnancy decides that she wants to surrender her child at the hospital. Now, I say the mother, but it could be a father, but almost always is the mother who is in distress. And she can surrender that child within 72 hours of birth, preferably at a hospital, because that's the safest place to surrender a baby. And once she does that, the hospital contacts the child placing agency, and the child goes home with a prospective adoptive family. Now, there's a lot of time periods that are at play here. There's the child placing agency has to give notice to both the surrendering parent and the non-surrendering parent, and they only have 28 days to come to court to request custody. Now, if either one of them come to court to request custody, the very first thing that has to happen is there has to be DNA testing. Because one, we're not going to let any man come into court and request custody until he proves that he is the biological father of the child. And if it's the mother who's requesting custody, she has to provide DNA testing unless the emergency service provider, like the hospital, observed her giving birth to the child. Even if DNA is established, the trial court still has to decide whether it's in the best interest of the child to have custody with the surrendering or non-surrendering parent. Now, if neither one of them show up and request custody, their rights are terminated. It's the end of it, and the adoption can be finalized. But there's a whole process that goes into place if those parents, either one of them, comes in to request custody. So it is another option that a lot of people don't know about. Now, if you want to know more about how to protect your clients and make the world a better place, better laws, go to liisaspeaker.com. It's my personal website. You can click on the link below, and we talk about a lot of ways that you can educate yourself and help us make the laws better.